Hey guys, this is Ohio nursing home abuse lawyer Will Eady. I am popping on to talk for a second about something we see all the time in our nursing home abuse cases, and I think this is true across the country, and that's when the defendants, could be the defense lawyer, could be the insurance adjuster, even the judge, ask a family who've lost a loved one in a nursing home to agree to what's called confidentiality. And put simply, confidentiality is when when you sign a contract that says, I'm not going to talk about what happened. And it could be that it requires you not to talk about the amount of the settlement. It could be that it requires you not to talk about details of the case, your allegations in the case. There's lots of ways they frame this, but the end result is my client, who is usually the estate and representing the family and beneficiaries of the estate who've lost a loved one due to carelessness, neglect, sometimes even recklessness of a nursing home that they trusted with that care, is going to be contractually obligated to stay silent about this. And that really bugs me. That bugs our firm, Eady Hill Trial Lawyers, for a few reasons. Number one, part of the whole point of a lawsuit is that the defendant hasn't agreed to take responsibility for what happened, and they've forced the family to file a lawsuit. And in America, lawsuits are public. That means that the complaint and other publicly filed documents are available to you. That could be a reporter who wants to find out about it. That could be someone who wants to investigate a nursing home as a possible place to send a loved one, wants to see who sued them and why. And it could be to help understand what's going on in our civil justice system, which is very different and less tracked than our criminal justice system. And to basically put a gag order on this family goes against their motivation. And I'll tell you, the number one motivation for the families I work with is, and I can say this without reservation, is never money. Okay? There's no check I can get them that they're going to be happy that they lost a loved one, period. There just isn't. If there was a magic button I could give them and said, you can't have any money, but you can go back in time and have avoided this loss, have your parent or sibling have a death that had dignity and was expected and wasn't due to carelessness, they'd push that button every day. So the real reason they call me, the real reason they want to move forward and go through the time and energy and expense of a legal process, which isn't easy, is because they want accountability. They want to know what happened, which often the facility won't tell them. And if what happened was caregiver carelessness resulted in death of a loved one, they want some accountability for that. They want that nursing home to take responsibility. And in our system, we don't have duels. We don't burn the place down. We don't have feuds. We have lawsuits. And so agreeing to confidentiality really makes it transactional. It makes it about the money when, in fact, what the family really wants is accountability. And accountability comes with sunshine, with transparency, with public disclosure. Another reason I don't think confidentiality agreements make sense is that, particularly in a wrongful death case, the settlement details, often the settlement agreement, sometimes this, and always the settlement amount, is publicly filed in the probate court. So just because you have a private lawsuit, quote unquote, between private individuals filed in a public court, they can't just agree to settle the case when there's a death involved. So we have a system of courts called probate courts in most states, including Ohio, that handle things where there's a death involved, incompetence because of mental infirmity, or you're too young, children, things like that. And the job of the probate court is to make sure everything's fair, to make sure that this total resolution is fair, and to make sure that how it's distributed amongst the beneficiaries is fair. And so the probate court's going to have to sign off on the settlement. And to do that, I'm going to have to submit a copy of the settlement agreement, a copy of the amount of the settlement, to whom we are proposing it be distributed, and have a court often hold a public hearing to make sure that that's okay. So the whole idea that this would ever be confidential is a myth. And it's really just putting the family, who have every right to say whatever they want about this, in the position of taking on potential liability, which I don't think is fair to them. I also think the real motivation here is that they want to scare the family when people ask what happened with that, when people ask, what do you think of this nursing home, into thinking that they don't have the right to tell the truth. And that's something I disagree with. You see this with this Harvey Weinstein business and all this Me Too movement stuff, where you find out there have been prior instances of misconduct, but those are put in there's a confidentiality agreement signed with the resolution of that. That meant other people working with those predators would never learn of that. And I think if the nursing home wants to take responsibility, step up, fix their system, do a better job, and prevent these types of things from happening, good for them. But if not, then people should know or be able to find out that this kind of thing is happening at this facility. Another reason I think they want this is they don't want me as a plaintiff's attorney to be able to talk with other plaintiff's attorneys about how much we resolved the case for. Why not? Because what I find they often tell me is, well, Will, these cases just aren't worth that much. These are old people. This is a conservative county. This is rural Ohio. You're never going to get a verdict here. So this family should accept less. Now, one way to counteract that is to be aware of other verdicts and settlements that have occurred, and be able to push back and say, no, in fact, this does, these jurors in these communities do award big verdicts. And frankly, you have settled other cases for more money than this. So there's this myth that these insurance companies want to put out there that, well, just because they're not from a city, just because they're conservative people, they won't recognize injustice. They won't punish wrongdoers when there are punitive damages involved. And I just don't think that's true. Okay. I'm probably in the more liberal end of the spectrum, and I live in a city. But I have no problem with these cases in very rural or conservative-minded counties, because what I find is those communities, it's not that they are against awarding money. It's not that they're against lawsuits. They don't like frivolous lawsuits. I don't file those, so I'm not worried about that. And they appreciate rules. And rules are really all about what all these cases are all about, are rules. So I think it arms us as representatives of regular folk when we know what's going on in terms of settlements. Because those insurance companies know, believe me, they talk to each other. They have their databases. They know when they tell you, oh, you'll never get more than this much money, that's not true. And they use that imbalance of knowledge against us. So the last thing I want to say about confidentiality agreements is that I think they're just against the whole idea of public access to the courts. So in this country, in the United States of America, you have a constitutional right to a jury trial. And that's not just in criminal cases, that's in civil cases as well. And so when we hide what goes on in our justice system, even on the civil side, I think that degrades the public nature of our court system. And there's a reason it's public. It's because the way things came down from the English system, the king had to decide that he was going to allow you to bring a lawsuit. The king had to decide that you could sue him. And we kind of wiped that away, except in some very rare cases like suing the state government, where they have to pass a law to say that's okay, and they have in most states. We don't have to ask anyone's permission. We don't have to, and we don't get to hide what goes on there. We don't get to hide witnesses. We don't get to hide facts. So the idea that we would just agree after going through this whole process to hide from the public what the result was. So all they see is a lawsuit's filed, some things happen, and then dismissed, and no one knows what happened after that, I think is really counter to what our system of justice stands for and what it should be. So that's why I don't believe in confidentiality agreements. That's why our law firm always insists that clients consider not signing them and never recommend them. And if you have questions, if you're a lawyer who is being told in your state that just can't work for you, if you're somebody who is looking at a nursing home case and has questions about a case, or you just have thoughts on our justice system altogether, go go ahead, leave a comment, and I'll try to respond to those as soon as possible. Thanks.